Hello and welcome back. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on estate planning, trusts, property, taxes, family, legacy, and everything else on my clients' minds. On this podcast, we talk a lot about the potential advantages of transferring wealth, but we have to talk a lot about the pitfalls, this terrible irony that sometimes transferring wealth in the wrong way or at the wrong times or for the wrong reasons can have negative consequences and can actually work against the goals of the donor. These are challenging issues to talk about and think about, and it's sad to think about those situations. On this episode, we're going to address an even more challenging and sad situation, a beneficiary who suffers from substance abuse. There are obviously lots of ways that people can abuse something or be addicted to something. Just as a few examples that come to mind, someone could abuse illegal drugs, legal drugs or alcohol, gambling. Just consider when there are ads for gambling, there are often those caveats at the end of the ad about hotlines to call if someone has trouble stopping gambling, and any number of other substances or activities. On this episode, we're not going to try to diagnose anybody, and we're not going to try to give some definitive definition of addiction or substance abuse. But one key point, if there are these concerns about substance abuse, then the donor or the trustee might be well served to retain experts in this field to advise them about what issues to look for and what might be best for the beneficiary to help facilitate that recovery. We'll get to that. But the general idea is that an addiction or abuse is the use of something that interferes with someone's personal and professional development. It's that unhealthy use. And the obvious challenge with receiving wealth is that it can actually enable those kinds of negative behaviors. You can imagine the scenario where a beneficiary doesn't feel the consequences of his or her actions or lifestyle because of the wealth that's there. So perhaps as we think about issues of transferring wealth and concerns about substance abuse, the first rule should be do no harm. Let's try to act at least to not enable those kinds of addictive or abusive behaviors. And then maybe the second rule is help recovery. Let's try to find a way to use this wealth to facilitate treatment and recovery from those behaviors. Let's start with a general observation about individuals with issues of substance abuse and addiction. This is often not an issue of someone being legally disabled. There are lots of definitions of someone being legally disabled, but generally it's the idea that someone cannot manage his or her own finances. Maybe they don't understand how to pay bills, for example. Think back to this podcast in episode 6. In the case of Harrison and the idea of a holdback trust. In that case, the father, as trustee, wanted to keep funds in trust because he thought his son was disabled because of various issues, including the son's alleged use of marijuana. But there, the court found that there was not sufficient evidence that the son was disabled, so the court required a distribution from the trust. If the person really were legally disabled, there are other ways to address that. Again, see episode 6. This trust that addresses potential substance abuse concerns might also have separate language that kicks in if the person is fully disabled. But you can see that issues of substance abuse are separate from this question of legal disability. In the case of someone with substance abuse or addiction, their mental faculties might actually still be operating and functioning. In fact, there are many cases where this person's mental faculties are hyper-focused on one thing, continuing the addiction, even if it damages relationships and the person himself or herself. And we're also not talking about a kind of trust called a special needs trust or supplemental needs trust. This is a kind of trust where the beneficiary can still qualify for means-tested government benefits. That's a different kind of trust. It's going to have to be the subject of a different episode. A trust that tries to address substance abuse can incorporate special needs trust language so the beneficiary can qualify for government assistance without drawing on the trust funds. But you can see that issue of a special needs trust is a separate issue too. So this question of dealing with a beneficiary or a person with substance abuse problems is hard enough when the donor still has control of the funds. In that case, the person is asking for money to help, and the donor, maybe it's a parent, maybe it's a grandparent, other relative, still has the power to say no. That's hard enough. But it's even harder to deal with when the funds are out of control of that original donor. The funds might be already held outright by this beneficiary or individual, or they might be held in a trust for that person's benefit. So again, I told you this was going to be a challenging and sad episode. We're going to start to talk through how could you structure this trust and maybe try to address these very difficult situations of substance abuse. So this next question is this: if you want to make that gift, or if that gift has already been made, and you have concerns about substance abuse by a beneficiary, what do you do? On this podcast, we talk about 3 elements of a trust. First, access. Who can get distributions from the trust for this person's benefit? Second, control. Who makes decisions about those distributions? And third, flexibility. Who can make decisions to change the terms of the trust, maybe to change the terms about access and control? And we're going to unpack those 3 elements in this episode and how they might apply in the case of a donor who's concerned about substance abuse. In these cases, some clients want to keep everything very informal. They want to rely on a letter of wishes, which again was the subject of a recent episode in this podcast. They like to just draft the trust in a general way, but then have a separate letter to the trustee, non-binding, not legally binding, that tells the trustee, if a beneficiary is suffering from substance abuse, then the trustee should stop making distributions, for example, or should act accordingly. As you saw from that recent episode, I am a fan of those letters of wishes. I think they can be a great addition to the documentation of a trust. But my concern about a letter of wishes in this case is I don't think that letter of wishes often would be enough of a defense against that beneficiary who's suffering from substance abuse. There's another important lesson from the Harrison case back on episode 6. In that case, the father trustee held back the funds, and the son challenged the trustee and even sued his father in court. So in this case, we're envisioning a scenario where the beneficiary is suffering from substance abuse and wants more money, and the trustee says no. And the beneficiary pushes back and might even bring a lawsuit against the trustee. In those cases, the letter of wishes might not be enough for the trustee to hold up to deny that distribution. So if this issue of substance abuse is a concern of yours, it might be helpful to actually address each of those 3 elements of a trust in the trust document itself in a legally binding way. And this is where it's very important to draft the legal language right to make sure it's enforceable, even against that beneficiary who's challenging the trustee. So here are just a few thoughts of how to address each of those 3 elements in a trust if you're concerned about substance abuse. Again, the first element is access. Who can get distributions from the trust? Think about the terms of the trust. The trust might exist and allow distributions for the beneficiary's, quote, support. That is, the beneficiary might have a legal right to require the trustee to make distributions for his or her standard of living. So in one situation, the beneficiary might want more money, and the trustee might say that it's not in the beneficiary's best interest. Maybe the trustee has concerns that these funds will be used to further that substance abuse. But if the beneficiary has the right to distributions for, quote, support, then maybe he or she could bring a lawsuit to compel those kinds of distributions. So in those cases, it's important to build in different standards of distribution. Perhaps if there's a concern about substance abuse, the distribution standard could be very broad, something like allow the distribution beneficiary's best interests. In that case, the court might be much more deferential to the trustee if the trustee says no. Or maybe if the beneficiary is suffering from substance abuse, there could be a trigger in the trust document where the distribution standards change. And then the trust goes from distributions for, quote, support to distributions for, quote, best interests. Or maybe the trigger, once the trigger occurs, the trustee is directed to make distributions only for treatment of the beneficiary. Or perhaps the trust can also require that the trustee reasonably ask about the beneficiary's health before making distributions. And maybe the trust should also include language that says that the trustee is allowed to ask the beneficiary to submit to periodic health exams before the beneficiary can get any distributions. These are obviously very complicated provisions to include, and we want to make sure the language is phrased in the right way so it's, again, legally binding and enforceable and in the right ways. The second element, how about control? Who makes decisions about these distributions? Remember that the trustee is the one who is going to make the decisions about distributions. And recall in episodes 8 and 9, in many states, the beneficiary can actually serve as trustee. And as you remember from those episodes, in many cases, that works really well. But also recall, we said that if the beneficiary is serving as trustee, that often protects the trust from third parties like creditors. But the beneficiary as trustee has a lot of discretion. That is, the beneficiary as trustee often protects the trust assets from everyone, except from the beneficiary himself or herself. So if the beneficiary is suffering from substance abuse, is also trustee, then the beneficiary would have even more control over the funds, and others might have even less to do about it. So maybe in that case, the only option would be for a remainder or other beneficiary to bring an action for breach of fiduciary duty against the trustee to try to have him or her removed. And so that leads us to our third point. How about flexibility? Who can make decisions to change the terms of the trust? There are lots of ways to build in flexibility into the trust agreement. Again, think back to episode 22, this issue of something we called a power of appointment. This is the ability of the beneficiary to change how the assets pass during the beneficiary's life or upon his or her death. But now think back to that beneficiary who's trying to find ways to get access to trust funds. The beneficiary could use that power of appointment to benefit persons or others. Because remember, the holder of a power of appointment is not a fiduciary under traditional law and doesn't owe an obligation to anyone. So here's another example of how flexibility we build into the trust document could have these ironic and unfortunate consequences if the beneficiary is suffering from substance abuse and is able to exercise that power. So in this case, the trust might be drafted to say that if a beneficiary is suffering from substance abuse, then he or she can't exercise a power of appointment. By the way, that could have some interesting tax implications. So again, something to be very careful when you're drafting. Or maybe in these cases, it's helpful to think about flexibility in another way. Maybe we could involve another party in the trust. We sometimes call this a trust protector. This trust protector could step in and change the provisions for access or control, or even the powers of appointment, if this beneficiary is potentially suffering from substance abuse. But by the way, this raises another concern. Who's going to appoint that trust protector to begin with? Sometimes the trust says that the beneficiary has the power to appoint the trust protector, or the trustee has that power. But if the person who's suffering from substance abuse is the one who has to appoint the trust protector, then you can imagine that person might just decline to exercise that power. They won't appoint the trust protector at all, so the trust protector can't step in and make these changes. As you can see, as we look at a beneficiary who might be suffering from substance abuse, there are a host of concerns we might have about how to structure this trust. And again, maybe ways that flexibility and simplicity might be advantageous in one situation, but can especially have these negative and almost tragic implications in other situations. So in this podcast, we like to give you a takeaway, and I know this is a very challenging and sad topic, so it's hard to give you a really good takeaway, but maybe it's just this. Maybe it's just to ask, is substance abuse a concern of yours or of your family? And if so, think about how to incorporate that into your planning. And as you can see, there are a whole host of issues to address if that is a concern of yours. And I'll have to say, if it's worth addressing in a comprehensive way, and perhaps especially with respect to those three elements of access, control, and flexibility. I'm Steve Murphy, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.